Pursuant to Order 103, we have the reference to examine ArriveCAN.
From the Office of the Auditor General, Andrew Hayes, good to see you, Deputy Auditor General, and Lucie Després, Director. Nice to see you again as well. From the Office of the Procurement Ombudsman, Alexander Yeglich, Procurement Ombudsman, and also Derek Mercereau, Acting Director, Inquiries, Quality Assurance, and Risk Management. Mr. Hayes and Mr. Yeglich, you'll each be given a maximum of 5 minutes for your opening remark, after which we will proceed to rounds of questions. Mr. Hayes, as is custom, you'll begin first, please. Over to you.
Monsieur le Président, merci de nous.
Thank you, Chair. I thank you for again inviting us to discuss the report on ArriveCAN. I would like to acknowledge that this hearing is taking place on the traditional unceded territory of the Algonquin and Anishinaabe people. Joining me today is Lucie Després, who was the director of the audit. This audit examined whether the Canada Border Services Agency, the Public Health Agency of Canada, and Public Services and Procurement Canada managed all aspects of the ArriveCAN application in a way that delivered value for money. I will focus my remarks today on our findings related to the contracting practices. We found that the Canada Border Services Agency overall management of the contracts was very poor. Essential information was missing from awarded contracts, such as clear deliverables and the qualifications required of workers. When we looked at invoices approved by the agency, details about the work performed and who did the work were often missing. This contributed to our conclusions that the best value for money was, in fact, not achieved.
In our examination, we saw little documentation to support how and why the Canada Border Services Agency initially awarded GC Strategies the ArriveCAN contract through a non-competitive process. Only one potential contractor submitted a proposal, and that proposal did not come from GC Strategies. Also concerning, we found evidence that GC Strategies was involved in the development of requirements that were used when the agency later moved to a competitive process to award a $25 million contract for work on the ArriveCAN app. The requirements were very specific and narrow. This gave GC Strategies an advantage that other potential bidders did not have. Although the Procurement Ombudsman's review and our audit did not have the same scope, we have similar findings and recommendations as they relate to documenting the assessments and the decisions made in the awarding of contracts. We both found that basic contracting rules were simply not followed. Mr. Chair, this concludes my opening statement. We would be pleased to answer any questions that the committee may have. Thank you.
Thank you very much. And now turn to Mr. Yeglich. You have the floor for up to 5 minutes, please.
Perfect. Thank you. I'd like to begin by acknowledging that the land on which I'm joining you from is the traditional unceded territory of the Algonquin Anishinaabe people. Merci, Monsieur le Président, et merci aux membres du comité de m'avoir invité.
Thank you, Chair, and members of the committee for inviting me here today. My name is Alex Yeglich, and I appreciate the opportunity to appear before this committee to shed light on the findings of my office's recent report on procurement practices of federal arrivals with ArriveCAN.
Director of Inquiries, Quality Assurance, and Risk Management. I'd also like to acknowledge my esteemed colleagues from the Office of the Auditor General, who have also undertaken a review of this topic and shared the results of their findings in recent weeks. Mon bureau est indépendant des autres organisations.
My office is independent from other federal organizations, including PSPC Canada.
Minister of Public Services and Procurement Canada, but the Minister has no influence over my reports or reviews, and all my activities are concluded at arm's length from PSPC and other federal organizations. Excuse me. Notre mandat législatif.
Our legislative mandate is specific And it is to review complaints from Canadian suppliers about the award of a federal contract below $33,400 for goods and $133,800 for services. Secondly, to review complaints respecting the administration of a contract regardless of dollar value.
Dispute resolution services that Canadian businesses and departments can utilize to resolve contractual disputes. The process is voluntary, where my office's certified mediators assist parties in resolving disputes through a cost-effective and timely manner without resorting to litigation. There are no dollar value thresholds associated with our mediation services. And fourth, review the procurement practices of federal departments to assess fairness, openness, and transparency, and consistency with laws, policies, and guidelines, which led to my review of the ArriveCAN related contracts. On November 14th, 2022, the House of Commons Standing Committee on Government Operations and Estimates, OGO, adopted a motion recommending the conduct of a review by my office to assess whether contracts awarded by departments in relation to the ArriveCAN application were issued in a fair, open, and transparent manner, and whether contracts awarded on a non-competitive basis were issued in compliance with the Financial Administration Act, its regulations, and applicable policies and procedures. Once my office was able to establish reasonable grounds as per our regulatory requirements, the review was launched in January 2023. As per its legislated deadline, my office completed the review of ArriveCAN contracts on January 12, 2024. Le rapport a été publié en ligne sur le site web.
The report was published online at OPO's website on January 29, 2024.
A review of 41 competitive and non-competitive procurement processes and resulting contracts, contract amendments, task authorizations, or service orders under which work was performed for the creation, implementation, and maintenance of ArriveCAN. The review does not include subcontracts, as these are beyond the legal authorities of my position. CBSA was the client department for all 41 contracts. These contracts were established by CBSA by PSPC, by SSC Shared Services Canada, and by CBSA under its own contracting authority. Regarding competitive procurement practices leading to the award of contracts, all 23 solicitations reviewed were issued under a PSPC supply arrangement. Overall, solicitation documents were clear and contained information potential bidders required to prepare a responsive bid. For the most part, solicitations, solicitation amendments, and responses to questions from potential bidders were appropriately communicated, and bids were evaluated and contracts awarded in accordance with solicitation documents. However, mandatory criteria used in one solicitation leading to the award of a $25 million contract were overly restrictive and favored an existing CBSA supplier. My office has identified issues related to the achievement of best value in many procurements. For 10 of the 23 competitive procurements reviewed, the use of overly restrictive medium bands in the financial evaluation of bids stifled price competition and resulted in rejection of some otherwise high-quality bids. In roughly 76% of applicable contracts, resources proposed in the winning bid did not perform any work on the contract. This is known as bait and switch. When TAs were issued under these contracts, the suppliers offered up other resources, but not the individuals that had been proposed in order to win the contract. Files for non-competitive contracts included written justification for awarding the contract through a sole source process based on the exceptions to competition provided by the government contracts regulations. The reasons cited for not competing these contracts were that they were necessary due to the need being one of a pressing emergency, or only one supplier was capable of performing the work. Insufficient records maintained by Shared Services Canada raised questions as to whether certain service orders under the GC Cloud Framework Agreement followed appropriate procurement practices. There was no documented procurement strategy for work associated with the ArriveCAN, and multiple service orders issued to one supplier were treated as separate, unrelated requirements, despite the fact all were associated with ArriveCAN. A majority of the files reviewed were for professional services contracts through which were authorized under a TA, or task authorization. Overall, documentation of TAs used for ArriveCAN was complete and for the most part properly authorized. However, 20 TAs of the 143 reviewed did not include the specific tasks, including descriptions of the activities to be performed. Resources authorized to work on a contract with TAs must be assessed by the business owner before a TA is issued to ensure that the individual meets evaluation criteria for the resource category as specified in the contract. There were no assessments for more than 30 resources who were named on ArriveCAN related TAs. Overall, amendments to the contracts reviewed were appropriate and in line with the contracting policy. As the client department, CBSA was responsible for the proactive publication or public disclosure of contract information on the Open Government website for the contracts reviewed. Information was not proactively published for 17 of 41, or 41% of contracts reviewed. In these 17 cases, the original contract or one or more contract amendments were not available on the Open Government website. This result runs counter to broader government commitments to transparency and strengthen accountability within the public sector.
Thank you, Mr. Yeglick. I'm going to have to stop you there, but I'm sure you're going to get lots of follow-up questions, so I appreciate it. I'll give you a little extra time. Thank you. Turning now to Ms. Block. You have the floor for 6 minutes, please.
Thank you very much, Mr. Chair, and thank you to our witnesses for joining us today. I'm not a regular member of the Public Accounts Committee, but rather I serve on the Government Operations and Estimates Committee and have had the opportunity to hear from both of you in the very recent past. After your appearance at the Government Operations and Estimates Committee, Mr. Jeglick, the Auditor General tabled her report, and in it she found that GC Strategies was actually involved in the development of the criteria for the contract, which in your report you termed, and you mentioned it again today, overly restrictive and favored this existing CBSA supplier. 2 weeks ago, I sent your office a letter regarding this new discovery from the Auditor General's report related to the $25.3 million contract awarded to GC Strategies back in May of 2022. And as I indicated in my letter, I would like your office, you yourself, to investigate these findings and verify who allowed this private contractor to actually sit at the table and develop the criteria for a contract that they were obviously going to win. Will you undertake to investigate these findings and table the results with this committee?
So, Mr. Chair, thank you for the question and thank you for the letter. In addition to your letter, there was also the commitment made to the OGO chair that we would follow up in terms of looking at bait and switch more broadly. And so these are ongoing discussions within the office. As I've mentioned at committee, one of the factors that we must consider is reasonable grounds and who is best situated ultimately to conduct the review. I must admit we were troubled by that additional disclosure made in the OAG report. And we're trying to determine whether we're best positioned to conduct a secondary analysis or if there are other authorities who are better placed to do that analysis. But we will certainly respond to your letter in due course. And again, I appreciate the fact that you followed up. So thank you.
You're welcome. In regards to, I think what we heard for the first time at committee from you was the whole idea of bait and switch when it comes to task authorizations, identified resources being switched out. Of course, we've been given the reasoning at times that given the time that a project is, an RFP is put out and the project actually begins, some resources may not be available. But in your report, you noted 76% of resources did actually do no work as identified in those task authorizations. Is there an audit, or was there an audit done, or should there be an audit done to determine if, in fact, these resources were at the same skill level or higher, or whether or not they were actually below?
Thank you, Mr. Chair. So that's essentially what I alluded to in the first answer, is that is absolutely something we're considering doing, not just specific to ArriveCAN, but on a much broader scale to determine how prevalent the practice is. As mentioned at the OGO committee, the fact that it has a name is indicative of it's a troubling practice. And I have to admit also, upon reconsideration, I'm even more troubled by the percentage of 76%. And so it's something I'd happily discuss in further answers.
Thank you very much. In your report, you also described the alarming lack of documentation across the ArriveCAN contracts. Was there a specific department that was responsible for documentation that failed to collect and file it, or was this a problem across the departments mentioned, the CBSA, PSPC, and PHAC?
So I think a fair answer is that there was documentation issues across all. I will also say that we've recently conducted procurement practice reviews of all three of those departments and seen prevalent documentation issues that extend beyond the ArriveCAN. So as a result, we will be following up, and I'll mention this again at this committee, we do follow up on all of our reports 2 years after to determine whether in fact the recommendations were implemented. And so we did make a recommendation to the CBSA in relation to documentation practices, which we intend to follow up on shortly. So that will address CBSA, and again, PSPC and shared services equally have recommendations made associated with documentation practices, which we intend to follow up on.
Thank you.
You 1 minute.
1 minute, great. Just following up on the recommendations, we have obviously heard departments rightly saying we accept the recommendations that have been made by the procurement ombuds and the auditor general to make improvements to those processes. I think we've even seen some answers to those recommendations. But have you seen anything put in place that will actually ensure that what happened with ArriveCAN never happens again?
So I think I'll piggyback off of the last question around documentation, because that's the first issue that needs to be addressed immediately. I have witnessed some direct implications to the ArriveCAN recommendations, meaning witnesses appearing before this committee and other committees speaking to their commitment to make changes immediately and that are already impacting change. So I will say that I am impressed by the seriousness by which the recommendations are being taken. It seems like the actions are effective. However, time will tell.
Thank you very much. That is your time.
Chair,
now to Mr.
Point of order.
Yes, what's the point of order?
There, on the notice of meeting, there is a time allocation for the different sections, and it would be helpful for the committee to know how the time is being used.
So the intention is to run this for approximately 2 hours. Should we finish early for any reason, we will then go to line by line. But it is not the chair's prerogative or plans to keep us here beyond the allocated 2 hours.
But how long will the first section run till?
Well, so we're going to do 4 rounds, which is four rounds, which is customary. Good. Okay. Turning now to Mr. Chen, you have the floor for up to 6 minutes, please.
Thank you. Through you, Mr. Chair, to the Procurement Ombudsman. Section 29 of your report, and as you have alluded to today, in 76% of the applicable contracts, some or all of the resources proposed by the successful supplier did not perform any work on the contract. So to get some further clarity on this finding, changes were made to the resources in 76% of the contracts between the time of the contract award and the task authorization. Is this allowed in the rules for certain cases? Yes or no?
Yes and no.
Yes and no. Okay. So I'm hearing that in some cases, in exceptional cases perhaps, it is possible. Is the main issue you have with this that this type of situation happens far too frequently?
So I'll give you a general answer, and then I'll give you an ArriveCAN specific answer. The general answer is yes, it's the frequency with which this happens is a problem, but also you have to look at the specifics in this circumstance, which is why I find it offensive. And it's because the structure of the evaluation criteria was heavily weighted on the technical component. So there was a 70% premium based on the technical component, which was primarily an assessment of the resources. So those resources ultimately didn't perform perform any tasks, and some or all of the resources didn't perform tasks. So essentially, the criteria with which you're selecting the preferred proponent to deliver on the services is being selected for a reason that they don't ultimately deliver on. Right, and so that's troubling. And then, if you'll allow me, we talk about this in best value, in the best value section, but it has a cascading impact. So it starts with the 70-30 selection methodology, which diminishes the value of price. Then you have, I'll refer to it by bait and switch. So then you have the bait and switch. So the resources ultimately that you're selecting the preferred proponent based on are switched out of the process. And then you have this median bands issue on the already limited 30% price, right? And so it's really restricting the value of the price component. So as a result, what you're doing is you're selecting the preferred proponent based on a criteria that isn't playing out in material fact. And so that's what makes it so offensive.
Did you find any evidence that resources or subcontractors that were paid for the work, that there was no work performed?
So that is something I want to clarify, and I did clarify at the OGO committee. I think that is not what I'm saying in the report. It's not that the work was not performed. It's that the workers that were identified in the proposal, 76% of the time, some or all of those workers did not perform the work. But I think the troubling component is that was the predominant selection criteria of identifying who the preferred proponent should be.
And so we are aware that PSPC is tightening the rules as you recommended in your report. Regarding the rules you examined, when a substitution is made, the incoming resource had to have the same or similar qualifications as the ones originally listed. Is that correct?
So that's what should happen in practice. But that's not what we saw. We saw no correlation between the resource that was bid and the resources that were provided in the task authorization. And so had that happened, then I think it would have given us comfort that you were getting the same or better value. But because we never saw that replacement actually link the resources provided to the qualifications of the resource that wasn't actually delivering on any service, that's where I think there's a disconnect.
So you're saying that they may have been as qualified, but that was not clearly documented, and you don't have the proof for that.
And I will add that wasn't the metric by which they were tested. They were tested based on the mandatory criteria and the minimum point rated. So there was no testing against the criteria of the individuals who were bid on the proposal.
Well, in terms of controls around these types of swaps, what are they? Do they exist? And are there situations where it can be justified? I hear your point in that if a bid is being evaluated on certain criteria and it's specific to who is performing that work and they ultimately don't perform it, then that raises issues. But there certainly must be controls through which these processes can unfold or not unfold. Can you elaborate on that?
And this is what Public Services and Procurement said in their response as well, is perhaps they should look at evaluating other criteria, right? So instead of evaluating the resource that ultimately isn't performing the service, there are other criteria that should be looked at to determine who the preferred proponent should be. So that's one issue. The second issue is if we know this to be a practice, then perhaps the de-emphasizing of the price is not the right approach, because if in the end you get a resource who's closer to the mandatory or the minimum, the minimum rated, then I think price should matter much more.
Fair.
Very quickly, Mr. Chen, if you have a last question.
There's a saying that the outcome is what is most important. And do you say that in this situation that there was not best value for money?
So we didn't do a value for money analysis, but we did say that there's value lost with the way that the procurement was structured. So it wasn't best value.
Thank you very much. Maintenant, c'est Madame Sinclair Desgagnés.
Ms. Sinclair Desgagnés, 6 minutes. Thank you very much, Chair, and I want to thank the witnesses for being here today. Welcome to our committee. In French, do we say Jeklich as well? Jeglich? Okay, that works. Can you just confirm or not what the role of PSPC is in establishing the process of bidding for various departments and also for clients for the role that they play?
They were the contracting authority in 30 of those instances.
Parfait. Donc,
Perfect. And you point out in the report, you say that in terms of ArriveCAN, there were problems. Now, what we realize is that it's not necessarily a matter of bad documentation, as you confirmed earlier. It didn't just happen within the CBSA, but it also occurred for Amazon Web Services, Microsoft Canada, and there was the same type of thing occurring with Shared Services Canada. Am I correct? Yeah. Yes. ArriveCAN is really just a sample of what is happening throughout the government. It's the tip of the iceberg. This can be going on in a variety of departments.
Is certainly an issue that's prevalent. And the point I'd like to make is, at what point can you start making negative inferences associated with the lack of documentation? So is there a lack of documentation because of just poor record-keeping practices, or is there something else going on, right? And that's a question well, I can't answer that question because I don't know. But it is frustrating in my role to be able to come to a finding where I don't have the necessary information to make that determination.
mais dans votre rôle, vous devez aussi
In your role, you should also be able to see whether or not there was an exchange of emails, or in the case of ArriveCAN, a given person might have interfered to put their thumb on the scales to the benefit of, say, another person or a department. If there was a public servant that did that, and documentation would have an impact, and you would repeat it. It is your work, is it not, to know why there was no documentation? Can we just go beyond stating there was no documentation?
Chair, that's the comment I made about negative inferences, right? So where there's a gap in documentation at a critical moment in time, right? Yes, of course, I can say there's a lack of documentation and leave it there. But what I'm suggesting is at some point, negative inferences need to be taken, right? And so the way we've written our report is we try to draw some of these negative inferences in. So where there's a dispute between PSPC and CBSA about the applicability of one of the government contracting regulations exceptions, right? There's a back and forth that's happening. And at that critical moment where they're coming to some type of agreement as to whether it should apply or shouldn't apply, there's a lack of documentation, right? So what ultimately led, one organization to see the situation from the same eyes or the same lens that CBSA was, and that's where the documentation is lacking. So we wrote that section specifically with that negative inference in mind, that something clearly happened. I cannot infer too strongly because I don't know, but we certainly allege the facts in a way that it leads the reader to believe that there was clearly something that happened that we can't identify.
Parfait, merci.
Thank you. You also spoke of different other entities in your report. The Office of the Auditor General mentioned these as well, these other businesses, Talian, for example, which where we see a market rise in what they received, and several millions in the case of ArriveCAN. Have you noticed any similar instances in other businesses?
We mentioned certain suppliers by name is those were specific contracts that caught our attention. So we named the supplier by name and we included the value of the contract just to give a quantum to the reader to understand who the implicated parties were. And so for GC Strategies, there was a higher incidence in issues in those contracts, and that's why they were identified in the report. Specific to Dalian, the notation made in our report does not align necessarily with some of the other kind of witness testimony that they may have provided at the OGO committee. The notation we make about Dalian is they were a participant in a process where perhaps suppliers who were participating were made to believe that potentially 2 contracts would be issued, and in that instance only 1 contract was issued. So it's a question of transparency to the supplier community to make sure people aren't wasting their time.
Et à part Dalian, est-ce qu'il y en aurait d'autres entreprises, à votre avis?
And were there other suppliers other than Dalian that you noted that could have been part of the interference in the supply process, where there were bids that were made and proposals that were made to the benefit of certain suppliers?
Mr. Chair, that additional fact was made aware through the OAG report, and so that was something that was concerning to us. Your question is it possible perhaps for someone else to embed themselves in the federal government in such a way where they influence the outcome? You know, absolutely, it's possible, right? Every supplier who's embedded within a government department will have access to certain documentations, but to see it done in the manner that it has been kind of found in our report and also what's been found in the OAG is particularly troubling. And I do want to say for the supplier community, you know, it causes concerns because if there were any beliefs that this was happening, the fact that you now see it in 2 reports that this in fact did happen, I think is discouraging from a supplier community standpoint.
Et voilà. Merci beaucoup. Thank you very much.
Thank you.
MP Gazan joining us virtually. Nice to see you today. You have the floor for up to 6 minutes, please.
Thank you so much. And it's nice to visit this committee today and substitute for my good colleague, Blake Desjardins. This is to the Office of Procurement Ombudsman. So, I mean, concerning is right. Your department's report on emergency procurement highlighted the common challenges to procurement and services in an emergency such as COVID-19, as we are currently witnessing. By the way, before I go on, I just want to highlight the good work of my NDP colleague, Gord Johns, who actually brought forward the motion to commission the report, which, as we know, has shed tremendous light on many of the issues that are being discussed today and certainly all over the news. We know that this was an extremely important step for even what we're doing today to get more clarity around what happened with the ArriveCAN. But just circling back, the Attorney General, when bringing forward this report, previously commented, and I quote, and this is in quotes from the Attorney General, an emergency does not mean that all the rules go out the window and that the departments and agencies are no longer required to document their decisions and keep complete and accurate records. This is really troubling, very concerning. In your report, department's report, you identified certain steps in a national emergency that the government has to take, like the need for flexibility, centralizing, and ultimately having to rely on non-competitive contracting to save time and resources. However, the Auditor General is absolutely on point here. An emergency does not mean a disregard for rules and accountability. This is troubling. So my question here is, was the non-competitive process justified in this situation when it was done so poorly and resulted in a heightened lack of transparency and a wastage of resources?
So the invocation of the emergency exception under the government contracting regulations was in fact justified. The way that the supplier was ultimately selected, and that's a question that I believe this committee has asked about, and certainly the OGO committee has asked about. And again, in that circumstance, it's a little less clear why that specific supplier was selected to perform these directed or sole source contracts under the exception. But the application of the exception itself is correct. And I will thank you as well for drawing attention to the emergency procurement report we wrote. We wrote it during the pandemic to help procurement officials navigate some of the complexities associated with emergency procurement, which we knew to be a very difficult time for the procurement community. So I don't want that to be glossed over either. Many of these procurement officials were working day and night to deliver important goods and services for Canadians, and I just want to be able to acknowledge that that work was incredibly important. But in the ArriveCAN issue specifically, we did note that there were irregularities associated with documentation practices in the selection of the vendor who was ultimately delivering.
Yeah, and certainly, I hope I don't. It doesn't appear that I am putting down the hard work of our civil servants, but in this particular case, we know there's weak financial records. At a time when we're running deficits, this is a total colossal waste of taxpayer dollars, and we also know that because of this, external resources were used. This increased the cost, and it did not, in turn affect the efficiency. Do you think this could have been avoided if instead of contracting out to, different agencies that seem to be problematic, that there needs to be instead more support to the public service?
Right. So really that was the determination made by the CBSA. So I can't comment on their internal capacity to deliver these specific services. Obviously, they made the determination that they could not. I'm in no position to question whether, in fact, they could have delivered internally as opposed to hiring external resources. So
would you say that as a going forward practice, that one of the strategies could be to ensure that there's enough human resources internally so that we don't end up in these having these issues in the future?
Well, separately to this committee, I think it's been well understood that there is a gap in terms of the IT expertise available not just in the public sector but in the private sector as well, which I think has been spoken about on a number of occasions. That being said, I'm not in a position to comment as to whether the right approach is to retain more internal resources.
So would you say that as I asked or indicated that it was done so poorly that it resulted in a heightened lack of transparency and a wastage of resources? Do you have any sense of how much of the resources were wasted? How much we could have saved if it had been done properly?
So that question is probably better positioned for the Office of the Auditor General, because that's part of this, or at least closer to the scope of the OAG review. That being said, I will comment on the fact that, of course, this could have been done better in many regards, particularly with documentation. And again, you mentioned transparency a number of times in your question, and I think that's fundamentally what's causing so much of the concern, is that there was very little transparency associated with many of these procurement processes, and it's causing people to ask questions that now go unanswered because there's no documentation demonstrating why decisions were taken.
Thank you very much. That is the time. Beginning our second round, Mr. Genuis, you have the floor for 5 minutes, please.
Today, the RCMP commissioner has confirmed that the police are investigating the ArriveCAN scandal. We're increasingly seeing that the NDP Liberal government's ArriveCAN scandal was costly, was corrupt, and also was criminal. I want to start with questions to the Auditor General. And I'm perplexed by the fact that Liberals are laughing in response to this line of questions. There's nothing funny about this. $60 million that was wasted of taxpayers' money, corruption, bid rigging, RCMP investigations. I'm sorry, there's just nothing funny about this at all, and I think people that are struggling under the burden of taxes that are paid for this kind of waste and corruption don't find it funny either. But anyways, to the Auditor General, have you communicated with the RCMP? Have they asked for documentation? What kind of information have you been able to provide them?
Thank you. Before our report was submitted to Parliament on the 12th of February, we had spoken with the RCMP to make them aware that our report was coming. We did signal to the RCMP at that time that if they were interested in receiving information from us, that we would be happy to share it in response to a production order. And we wrote to the RCMP afterwards confirming the same.
Okay, thank you. Similar question for the procurement ombudsman. Have you communicated with the RCMP? Have you been providing information in relation to your work and your findings?
So we have not had any communication with the RCMP. At the time that it became public information that the RCMP may consider investigating, it was at that point we considered what the appropriate steps would be. We felt the best thing we could do was put our report on the public record as quickly as possible so that that information could be made known to the RCMP. And we made comments to that effect also before the OGO committee.
Okay, thank you. Sticking with procurement ombudsman, were you surprised by the RCMP announcement today based on the work you've done?
So I just want to answer this as factually as possible. So it's in addition to everything else that we've learned. So based on the information contained in our report and the documentation that we saw, I would answer yes, I'm surprised. However, based on all of the other additional information, including information that was provided by the OAG, I'm not surprised.
Okay. So in light of everything you know at this point, you're not surprised by the investigation?
Right. I'm reluctant to say anything that we didn't review. It's difficult for me to have a view on because I didn't do the review. So that's why I said the comment in the way that I did. Certainly, we rely heavily on the work of the OAG. And so where there's factual findings that there were communications between the supplier and the department that led to the supplier ultimately providing restrictive criteria is highly troubling.
Yeah, highly troubling in the sense that it wouldn't surprise you that the RCMP would be investigating that.
Correct.
Yeah. Back to the Auditor General's team. Were you surprised by the confirmation from the RCMP today, or not surprised based on what you know so far?
Based on the fact that the RCMP had already signaled that they were examining the allegations raised by Bottler that involved many of the similar individuals that were involved in ArriveCAN, it's not surprising to me that they would take a broader look at the matters before them.
Okay. Both of your reports dealt with rigging of the process in different ways, actually. But I think we see at various points a kind of rigging of the process in GC Strategy's favor. Would the rigging that your reports identified constitute criminal activity?
I think I'll start with this one. The concerns that we raised were really about public servants undertaking activities that gave GC Strategies an advantage, whether it's in the non-competitive context where the GC Strategies hadn't even provided a proposal but won that first contract, or whether it's in the competitive process where there was in GC Strategies' involvement in setting the requirements. Those to us are concerns. It raises questions about whether or not there was bias or unfair advantage. But whether it's criminal, that's really a matter for the RCMP.
Okay. Would you like to comment on whether the rigging component specifically appears to be criminal?
I will kind of answer in the same way that my colleague finished, which is now that there actually is an investigation, I think any kind of commentary around criminality is inappropriate. Let the RCMP make that determination.
Thank you very much. That is your time, Mr. Genuous. Turning out to Ms. Khalid. You have the floor for 5 minutes.
Thank you very much, Chair, and thank you to the witnesses for being here today. Really appreciate it. Just a couple of things. I'll turn to the ombudsperson first. Now, does your report allege corruption by public servants?
So there's no direct allegations of corruption in the report. As I said, our report is intended to be factual in nature. We don't identify individuals. We identify procurement practices, which is the nature of the review. If, by virtue of some of the practices that we've identified, it results in a secondary review, that's not a bad thing.
And does your report allege any political interference by any minister or any elected official?
Mr. Chair, no, it does not.
Thank you for that. Now, I really appreciated your recommendations and your findings. I thought that they were reasonable and they were practical and actionable. So can you give us a bit of a rundown as to what actions have been taken based on those findings and recommendations so far, and what do you think the government needs to further do?
So essentially what you would have seen in our report is the proposed management action plan on behalf of all three departments. In terms of me being able to comment on what has been implemented to date, we've done no testing, but as I mentioned, we will do a follow-up 2 years after to ensure that each one of the 13 recommendations has an assessment as to whether they've been fully implemented or not.
Thank you. And in the past, you have expressed some frustrations about your recommendations or lack of action on them. Do you want to comment a little bit as to what your expectations are with these recommendations?
So I wouldn't say I'm frustrated by the lack of compliance with the recommendations. I will say that that is the purpose of our follow-up examinations, is to ensure compliance. I mean, the main goal for our office is to make the procurement system work better for everyone, right? And so we always make recommendations with that in mind. The ArriveCAN circumstance is no different. The intention behind each one of the recommendations is to improve the process. And so I appreciate you kind of recognizing the practicality behind the recommendations, because we've identified what we think are some fixable problems. But I also know, as part of other questions, there are larger scale issues that I still think go unaddressed by some of the recommendations.
Thank you. And just on those recommendations, I really appreciate that you outlined that PSPC needs to play a better oversight role. In fact, you have a whole section in the report on it. But I want to turn to an example that you had provided with respect to emergency issues and its management within the procurement world. You had talked about the way that Hurricane Katrina was dealt with. Can you perhaps expand on that a little bit in its comparison to COVID-19 procurement in Canada?
So to be completely honest with you, I hadn't been made aware that the emergency procurement piece that we had written about would come up today. So specifically on the Hurricane Katrina example, I'd prefer to provide you a written answer, so to make sure it's factually accurate.
Thank you. I really appreciate that. And just on balance, we talk about transparency and the need for efficiency within our public procurement system, and how those relationships work with contractors that are perhaps embedded in the system or who have built trust within the procurement system within our country. What would be the number one thing, very practically, what you think that we can do to make sure that these kind of issues don't happen going forward?
Well, I think at a basic element, when you embed contractors within government departments, I think we can never fall prey to the notion that we are all the same when we're in the same working environment. They always have to be mindful of the fact that these are individuals who have a different incentive, a different role, and therefore when they're being made privy to information, you must be mindful of the fact that these are not employees. These are private contractors who are incentivized to continue to win government business. So to protect the fairness of the process, you must always maintain that at the heart of all decisions, in terms of including them in discussions, in how you interact with them. There's a reason why they're defined as consultants and not employees. Derek,
Thank you. And
a brief question, Ms. Khalid, if you
very,
have.
very brief question. With respect to the Lobbying Act, and once PSPC employees retire, do you think that we need to have another visit at the Lobbying Act to address some of these challenges?
So while I like to answer all questions as directly as possible, I think commenting on the Lobbying Act is probably beyond the parameters of my mandate, so thank you.
Thank you very much. Encore une fois, Madame Sinclair-Desgagnés.
Madame Sinclair-Desgagnés. Thank you very much, Chair. I'd like to move on to something that is a non-competitive contract. You said in your report that there were some contracts that were awarded non-competitively. can you tell me, in theory, I know that there are standards that are set in terms of amounts of money under 25,000, I believe, you can issue a non-compete contract. And if memory serves me, it's over $1,000, there has to be a competition. I myself was a consultant, so I'm trying to remember. So with respect to these non-competitive contracts, what should be the best proportion that should be established for these non-compete contracts?
Or sole source contract is absolutely within the rules in certain circumstances, right? So it's specifically contemplated in the government contracting regulations. It's Section 6, and there's 4 specific examples that are considered appropriate. The first being for emergency circumstances, which we did look at, and we found it to be an appropriate allocation of the exception. The others being you mentioned the monetary thresholds, right? And so those were somewhat recently updated, so it's 25,000. And I'm generalizing here for goods, and 40,000 for services. The third exception is if it's not in the public interest. So an example of that is a correlation between the national security aspect, and then the fourth is if there's only one supplier that's capable of doing the service. Now, there's some sensitivities associated with identifying, only one supplier capable of performing, because I think sometimes it became a virtue of it's the only supplier we know, as opposed to the only supplier that actually can. So the Treasury Board has quite a comprehensive document with 7 questions that need to be asked and answered in terms of invoking that last exception associated with only one supplier being available. But all that to say that these are exceptions that are absolutely acceptable. They're captured in the government.
C'était pas la nature de ma question.
But that really wasn't the nature of my question, but unfortunately I'm out of time.
Vous allez encore une tour.
You have another turn.
5 minutes, please. Oh, I believe you're on mute. Oh, you're still on mute. Actually, I'm not seeing the mute button. Yeah, so we will come back to you. Oh, now. Oh, yes, I can see you're off mute, but there's nothing coming through. Yeah. Is your headphone attached? We'll just double check that. That's, I know, an obvious one. I can't hear you. Could you just double check that the headphone's attached? The wire. The wire, yes. It is. The clerk will have someone give you a call. Yes, Why don't we come back to you, Ms. Kazan?
Okay, can you hear me now?
Now it is working.
Oh, okay, I plugged it. I took it out and I plugged it back in.
Thank you, Miss Yip was right on that. So you have 2.5 minutes, please. No trouble. 2.5 minutes.
Okay. Yes. So I was wondering. I know I had asked, how much would have we saved if it was done properly? If I could ask the Auditor General's office to provide the committee with that information. But moving on to my next question. OAG commented previously that PSPC co-signed task authorizations by the CBSA, which increased time and resource commitments without adding new tasks or deliverables. Costs and time commitments increased, but the net benefit remained nil. And, there's so many concerns that are being brought up about, costs that should have never happened, expenses that should have never happened. In fact, in the report, you noted that 76% of the applicable contracts, some or all of the resources proposed by the successful supplier did not perform any work on the contract. Internal resources and limiting outsourcing would fix this issue. Do you agree with this? And if so, could you please elaborate?
So the reliance on outsourcing, I guess if you're suggesting that that there would be no need to outsource any work, then the bait and switch issue would go away in the sense that you're not doing any procurement, right? But in terms of would just simply adding additional internal resourcing address the notion of suppliers who are being put forward by, resources being put forward by suppliers, I'm not sure I see the correlation between the two.
Okay, well, just basically, I mean, we see a pattern with procurement, certainly with this government and the former Conservative government of, hiring outside consultants to do work that they're not doing rather than building the internal capacity and supporting folks that are working in the system in terms of HR practices and hiring. Would you agree that if we stopped as much outsourcing as we currently do and instead invested in building a robust public service, we would be saving money?
So, Mr. Chair, unfortunately, I can't comment on the monetary savings, but certainly I think the premise of if you have more internal resources, would you be less reliant on external consultants? And I think that's a fair assumption.
Thank you. That is
Okay,
your time.
can I pass? Oh, sorry.
No,
Thank you.
You will have another turn or two. Mr. Genuis, you have the floor for 5 minutes, please.
Thank you, Chair. To Mr. Jeglick, would you expect ministers to be briefed on large procurement items like this? Is that part of the best practice? Is it plausible that this process could have unfolded with no ministers knowing anything? And did you find evidence about the inclusion of ministers or their staff in these conversations?
So I would say the involvement of political actors in the procurement process is problematic, right? So there should be no involvement from political actors. Once a procurement process is set in motion, it's very important to follow the rules set out. So if there's an evaluation process that ultimately is designed to determine who the successful supplier is, there should be no involvement from political actors. In terms of external briefings, I would hope that those briefings would happen in such a way that there is no direct involvement of any politician in an active procurement process.
So that's the best practice you described, what should happen. I guess in this case, the absence of records makes it hard to know what did happen. Or do you have any insight on whether best practice was followed here?
So what I can say is, yes, you're correct in the fact that there's documentation missing, but we saw no evidence of any political actors interfering in any of the procurements based on the documentation that we were able to see.
Okay, so based on what you're able to see, basically, but the absence of documentation makes it uncertain.
Right. Sorry.
Yeah. So just you can tell me, is that correct?
No, I was going to say yes, absolutely.
Okay. So as we go through this process, we are finding out more based on your reports about what happened, when it happened, where. There remains a gap as to why. Why were documents either not created or destroyed? Why were processes rigged? Why was there such a desire within government to fit the square peg of GC strategies into this round hole, which was an IT project that they had no expertise on? Do you have any reflections based on the work you did about why the government proceeded in this fashion? I'd be curious to hear from both you, Mr. Jeglick, and the Auditor General's office.
So again, that's the troubling component in that you cannot come to a conclusion as to why certain things were done. And that's, I guess, I'm sure I share the frustration in the Auditor General's perspective as well, in that the findings are difficult to make where you don't have sufficient information to be able to have a finding. The observations we made and the recommendations associated with those observations and findings were based on the documentation that was available. Certainly, we do spend time trying to identify what possible issues could have arisen. even specific to that $25.2 million contract that was awarded to GC Strategies. I think there were some abnormalities that still warrant further discussion, right? So what was disclosed in the Auditor General's report was something that we weren't aware of, that the supplier was involved in developing these restrictive criteria. But then at the same time, we also noted that there were 40 participants that were eligible and 10 identified an interest in participating in the process. So it's a little bit unclear as to why none of those 10 parties participated in the process, even though they identified having an interest in participating. So again, there's a question there in our minds that remains unanswered. And so,
somebody did something here that was totally wrong. We don't know why. They must have had a reason, but we don't know why. I'm going to give the tail end of my time here to Ms. Block, who had a follow-up question.
About 40 seconds.
Yes, and it probably segues quite well with what my colleague was just asking. I just want to make sure, Mr. Jeglich, that I understood your response to my question regarding the correspondence I sent to your office. And even in your answer just now, are you confirming that the AG's report and the findings regarding GC Strategies means that this remains an open file for further discussion or investigation with your office?
So our report is considered final. However, there are ongoing discussions within the office on components of the report that we're still looking into. So your letter did prompt further discussions as to additional facts that have been made aware to us after finalization of the report. Whether that generates a whole secondary review, that I can't comment on yet because we've not done the analysis. But I will say, and as I answered before, there is that and the secondary issue of the bait and switch review that we're also actively contemplating. That would
Thank you. I'm going to. I appreciate it. I'm over the time, but I know you had said that previously, so I'm going to just rope that off there. Turning now to Ms. Shanahan. You have the floor for 5 minutes, please.
Well, thank you very much, Chair. And I was afraid that I had missed important elements of our hearings by not being present last week. My apologies to all my colleagues. But I am very happy to be here today, and I greatly appreciate the testimony that we are hearing here today, not only from our Deputy Auditor General, Mr. Hayes, but also from the ombuds, the procurement ombuds, Mr. Jeglich. And it's very important to this committee, to the Public Accounts Committee, that we have a clear understanding of the procurement process and the fact that it is independent of all political interference, and indeed that is what you have seen to date, albeit that there were other issues that were happening that were of great concern. And let me just say, Chair, where I was last week with Canada-Africa Parliamentary Association in Tanzania, great interest from the parliamentarians there about our Public Accounts Committee and how we work with independent officers of Parliament and how we proceed with our work. So my first question would be that I'm glad to see that PSPC has suspended the task authorization authority for all 87 departments and agencies that it contracts for when it comes to IT professional services, because I think we agree that IT is definitely a very problematic area of procurement, not just for the CBSA, not just for the companies involved in ArriveCAN, but everybody. PSPC is doing this until they sign new agreements that incorporate the rule changes that you have suggested. So first, I'd like to get your reaction to this. It seems very dramatic, but do you feel that it's appropriate?
Well, certainly aligned with what we saw with CBSA. That's why we made the recommendation we did. We didn't request that they do so for all other departments and agencies, but I think they would have a better vantage point based on their interactions of other departments and agencies that weren't subjected to this review. So am I happy with the outcome? I'm happy that they've complied with the recommendation. In terms of the need to add additional departments and agencies, I can't comment on.
Well, indeed, and that was the kind of questioning that I would have liked to have put to the PSPC myself. Unfortunately, they were here one day and not permitted to provide their testimony, and I missed that subsequent meeting. But it was definitely a concern of mine that the oversight did not seem to be adequate, even during that emergency period. And so I see that a number of your recommendations deal with document retention, and it seems to me there should be a system where that there's a fail-safe, that has to happen. PSPC says that it has introduced a new electronic procurement system last year that will ensure that all documents are kept together rather than having to rely on public servants attaching emails to the right files. It does seem a little ad hoc. Have you had a chance to evaluate this new system, and do you think it'll be helpful?
So in terms of being able to review the new system, we have not. We've received briefings on the system and some of its capabilities at its early stages and throughout implementation. Do I think it will assist in documentation? Absolutely. But can I comment on its effectiveness? I cannot. The one thing I will say is that there was a change. So before, the rule that would apply to most federal government contracting was something called the Treasury Board contracting policy, and that has since been phased out effective May 2022. There was a phase-in period of 1 year. The new directive makes clear, based on roles and responsibility, who has the obligations associated with documentation, and it makes clear that the documentation obligation lies with the contracting authority. So the contracting authority, as I mentioned, in 30 of these instances was PSPC, in 7 instances it was shared services, and in 4 instances it was the CBSA themselves. I saw Derek indicating he wanted to add something, and I feel like I've been domineering the conversation, so thank you.
If I could, just in relation to the new system, the PSPC had referred to it, it's a SAP Ariba system. We'll note that the $25 million contract that was awarded to GC Strategies was issued through that system. So that is how we were able to know that there were 40 eligible suppliers to bid, and that's where we saw the information that 10 had indicated that they had an interest in bidding, though didn't. Though, as you can see, there were still issues associated with that procurement process. So don't want to give, it sounds good and it can improve practices, but the system itself won't lead to all the improvements that have to happen.
Thank you very much. That is the time now to beginning our third round. Mr. Nader, you have the floor, please, for 5 minutes.
Thank you, Mr. Chair, and again, thank you to our witnesses for joining us today. I might begin with just a quick comment. Having read the Procurement Ombuds report, having read the Auditor General's report, having heard testimony at this committee at OGO, it's quite frankly shocking that an agency that falls under the public safety portfolio has allowed such a culture to be established where documentation isn't allowed or isn't in existence. It's just shocking that successive Liberal ministers have allowed this to come to fruition without a meaningful change coming from the top. So I offer that as a comment off the top. But second, it's been brought up about the concept of embedded contractors within CBSA and various other departments as well. But I'd be curious to know from the Procurement Ombuds whether they're aware of other situations within CBSA where embedded contractors are actively working and could have an influence on procurement contracts.
So, Mr. Chair, thank you for the question. Specifically, are we aware of other embedded contractors at CBSA? The answer is no. That doesn't mean that there aren't other embedded contractors. I would suggest there likely are. In terms of insulating them from having a repeat of these types of issues, I think everyone's attention across the procurement community is acutely aware now of some of the risks and pitfalls associated with having these embedded contractors, particularly involved as projects evolve.
Would your office have the capacity to undertake a review of all contracts at CBSA, specifically related to information technology?
So, Mr. Chair, this is where I'm going to make my plea. I've said this before, but Our office, I think, has an incredibly important mandate. I think the work that the office does adds significant value in all 4 areas that I highlight in my open remarks. There's 27 employees within my office, and they've been under incredible strain, if I'm being honest, for a fairly significant amount of time. So while I acknowledge absolutely that there is a need for us to continue the work we're doing, I'm a bit reluctant to openly acknowledge. I think that people would be kicking me under the table if they thought that I was going to say, yes, we can undertake another review. So in addition to the regulation, I think there are some practical realities. So I have put forward a request for additional funding to allow us to undertake some of these reviews. We did receive one-time funding last year to undertake both this review and that of McKinsey, but that is a 1-year funding allocation which expires at the end of this fiscal year. So to answer your question, would I consider, we could absolutely consider it. Can I tell you definitively that we would do it? I cannot.
No, I appreciate that, and I will just offer as a commentary. It's interesting that the government's able to find $80 million for a ArriveCAN, but can't find enough money to properly source a procurement ombud. So that's pretty disappointing. Having gone through extensive studies of CBSA, both the Auditor General's Office and the Procurement Ombud, would you suggest that now may be the time for Treasury Board to revoke the delegated procurement authority that CBSA currently possesses and have that revoked?
So it would be unfair for me, sorry, Mr. Chair, it would be unfair for me to make that comment. We had the opportunity to make recommendations. I think the recommendations we made reflect what we saw in the report at the time. We didn't suggest the Treasury Board revoking the contracting authority of the CBSA in its entirety, but I will say the previous member highlighted one of the recommendations with a real consequence, which is the authority for CBSA to issue task authorizations on their own account, right? And that's a significant recommendation that was made, and I anticipate seeing positive results, and it'll encourage CBSA to regain their authority by acting in a diligent and appropriate manner.
Mr. Hayes, any perspective from the OAG?
The CBSA has provided an action plan in response to our recommendations, and I think it's important to give the CBSA an opportunity to fix the weaknesses that we have identified. I would also say that as much as it is important to have controls in place, it is dangerous to over-control because you can grind everything to a halt. So I think it will be important for us as the OAG to follow up on the recommendations and the action plan that the CBSA has submitted.
Very briefly, Mr. Nader.
My 10 seconds for another round. Thanks, Chair.
The Chair, thanks you. Now, Ms. Yip, you have the floor for up to 5 minutes, please.
Thank you. Thank you for coming yet again. Your first 2 recommendations have to do with the median bands for prices. These are measures to avoid contractors who lowball their prices in order to win the contract and then jack up their prices halfway through the job when it is too late to stop. Pardon me. Can you speak about the factors you consider when deciding what is the right balance between finding the best price, but also one that isn't going to change halfway through the job?
Mr. Chair, thank you for the question. So the issue we had with the median bands was there was a change made with the formulation that originally or normally happens, and that's the median price plus 30% or minus 20% in terms of acceptable financial offerings. What ended up happening here is there was an alteration in the band, and it became, sorry, I've misspoken, right?
No, that's correct.
Okay, so
set to minus 10.
And it was set to minus 10. And so there is a problem in the sense that the clause that was meant to address this issue was geared towards the previous amount, right? So therefore, if someone made a competitive price offering, there was no opportunity for them to validate their price point and suggest that, yes, in fact, they could deliver the services at that price point. So in essence, what it did is it de-emphasized or de-incentivized people from bidding low, right? There was a higher incentive for them to bid high because it was less risky. Because if you sat outside of those bands, you would receive a 0 financial score. And you alluded into the reason why this methodology was implemented, and one of them was to prevent lowball offers, right? And I guess what that circumstance would present is someone bids at a price that's so low that when the task authorization is actually requested, that no resources are provided by that supplier because they're not able to do so at that price point. And so that would cause time wasting and frustration on the part of the department or agency. So I would suggest that the median bands issue was meant to address this lowball issue, and it was, I think, a valid attempt. I think in execution, it certainly didn't play out as anticipated, and as a result has had some unintended consequences, which we noted to be that in 4 instances, competitive priced bids were given 0-point allocations with no opportunity to rectify the price or explain the price, and therefore were not considered, even though on the technical side they were very strong.
I'd like to talk about the changes that were made to resources in 76% of the contracts between the time of contract award and the task authorization. Is this allowed under the rules for certain cases? Does it happen frequently?
So, Mr. Chair, this is a good question, and it's in relation to whether, in fact, we can give you baseline data. And we have no baseline data by which we can tell you 76% is more or less than this baseline data. I will say 76% strikes me as incredibly high. So if we find the baseline data to be any higher than 76%, then I will have a very different opinion on how significant this issue is. If this is an outlier and the baseline turns out to be much lower, then I think it's indicative of something that was somewhat unique to ArriveCAN. So without doing the review, it's a bit difficult for me to comment. That being said, is it within the rules? So it's, as mentioned in a previous question, it's the frequency with which this is happening that causes the concern. If it were just happening on a one-off basis because of a significant time lag, so the contract is awarded, months or even a year goes by, those resources are no longer available, yes, there is a mechanism by which they can and should be replaced in those circumstances. But where it looks and starts to feel like a business practice of identifying the best resources in hopes that that allows a specific vendor to obtain the contract, but then they have no intention of providing those resources in the performance of the work, then I think that it is problematic.
Did you find any evidence that resources or subcontractors were paid for work that was never performed?
So that's another important, Mr. Chair, another important clarification. So that was not something that we identified in our report. Unfortunately, in some circumstances, that's how it was reported, but that's not, in fact, what we found.
Okay.
Very briefly, Ms.
Okay, so this is in regards to the action plan. Have you received responses from PSPC, and have they met the timeline implementation?
So the responses that were included in the report were their actual management action plan responses. We don't comment on their action plan until such time that we do the follow-up. So ultimately what you see in our report is what PSPC, Shared Services, and CBSA responded to our recommendations and suggested they will put into place to respond to our recommendations. In terms of me being able to comment on their effectiveness, I wouldn't be able to truly do that until after we do our follow-up review.
Thank you very much. Et suivant, c'est Madame Sinclair Desgagnés.
Ms. Sinclair Desgagnés, you will have 2.5 minutes and another turn after this. I'm going to get to the point of my previous question. They were aware of the criteria for establishing a sole source contracts. I'm interested in the controls within the government itself. Do you find that it normal that after the pandemic in 2023 you have the criteria that weren't operating, the financial criteria weren't clear as well? Is it normal that in 2023 in a department, PSPC, made 27% of their contracts on a sole source basis? Or is it normal that within government there were 7,600 contracts of that ilk issued in 2023?
Is that I didn't more directly answer your question. In terms of the volume or frequency with which this is happening more recently outside of the pandemic, again, I will refer back to part of my answer is that there were certainly contemplated exceptions, and the frequency with which those exceptions are invoked, I mean, depends on the circumstance. So I would hope that the frequency that the emergency exception is invoked has greatly diminished over time, right? So during the pandemic,
Je vous confirme qu'il y a de plus.
I can say that there are increasingly a greater number of contracts like that. There were some in certainly during the pandemic, but in 2023 there's an increase from then on. So how can it be that we are having even more of these sole source contracts?
That question as directly as possible. But again, not having done a review in this area, I would be speculating as to why that might be happening. I think the first thing I would want to know is specifically which exception is being invoked in order to allow that to happen. I mean, if it were because of low dollar value, again, we wrote a paper on economies of scale and efficiency, fiscal efficiency associated as to when one should direct a contract for low dollar value threshold procurements. If it's for the other three exceptions being there's only one supplier, I think that would be troubling to learn that the frequency with which that exception is being invoked has escalated. But again, I don't know that to be a fact.
Mais parfait. Mais vous confirmez que ça devrait être une
But you'll confirm that it should be in the minority of cases. It shouldn't be in.
Has to meet the requirements of the regulations. And I'm not trying to skirt your question. I don't want to create a volume assessment. If it meets the exception and it's appropriate, it should be invoked.
Mais pas n'importe quelles exceptions.
But not just any exception. Thank you.
Gazan, you have the floor for 2.5 minutes, and as I was saying, you'll have an additional turn after this one.
Thank you so much. Just wanted to build on what I was asking before, because it seems with the outsourcing the way it is, it seems impossible to hold these companies accountable. It almost seems like it would be easier to invest in training the public service to fill this gap rather than, making the same mistake over and over again with the same results. Sorry about my dog at home. Sorry, everybody. We know private companies being, we've heard many private companies being untrustworthy and unreliable resource to undertake the work. And this was according to the Attorney General. It's impossible to determine the total costs, which is concerning because, again, this is taxpayer dollars and we should know and be able to very clearly confirm costs related to government spending. So again, to the Office of the Attorney General, in your recommendations in Report 1 on ArriveCAN, you highlighted that procurement decisions did not support value for money and government departments did not document due diligence. So I ask you again, did a breakdown in internal public service capacity cause this issue? What were your key findings and opinion in this regard?
Thank
Mr.
you.
Hayes, you have about a minute. If you finish before, and that's fine, but just so you know.
Yep, thank you. What we did highlight in our report was that there was a continued reliance on external resources. At the outset of the pandemic, when there was an emergency, the Border Services Agency did determine that it needed external resources. What we would have expected is that there would have been an analysis along the way to identify whether they could reduce their reliance on external resources. And we included an exhibit in the report that showed the difference between the reliance on external resources versus internal resources. We also did put out some numbers about the average per diem cost, the daily cost of external resources as being $1,090, whereas the average daily cost for an equivalent IT position in the government was $675. That's a little more than $400, which reinforces the point that it's important to have a look at when you can reduce your reliance on external contractors.
Thank you. That was well done. Next, we're turning back to Ms. Block. You have the floor for 5. I know I cut off an answer that you were, I think, in the process of hearing, but I know it was repetition. But it's over to you. 5 minutes, please.
Thank you very much, Mr. Chair, and I appreciate the diligence that you are demonstrating in keeping us to the time that we have been given. Mr. Jeglick, I'm going to come back to you. Throughout the course of our study on ArriveCAN, we have identified what I would say are extensive issues with scrutinizing subcontractors. In fact, we've learned from departments that the scrutiny of subcontractors is far less than those of contractors. And the Office of the Auditor General made it very clear to us at their appearance at OGO that their mandate restricts their ability to audit subcontractors, especially relating to value for money. So my question to you would be, is this an issue that concerns you, the inability to scrutinize, perhaps even the volume of times that subcontractors are used? And do you have the ability to make any recommendations for how to implement more oversight of subcontractors in government contracts?
Thank you, Mr. Chair. So I'll answer the question kind of backwards in the sense that we hear from subcontractors, specifically within our office, about issues that they're experiencing with the prime, looking for our services in hopes that we can help them. Unfortunately, we cannot. We have similar limitations to that of the OAG. That being said, and again, I didn't make this recommendation, but I will say by listening to much of the testimony here and that before the OGO committee, I do think there is a need for more transparency associated with monies that are from the federal purse that flow down to subcontractors. And I understand there's obviously privity of contract issues associated with information shared between the primes and subcontractors and subcontractors. But I do think that when you're involved in federal government contracting, there is an obligation of transparency. So while I couldn't make that recommendation because it wasn't appropriate given the parties subjected to this review, it's certainly an issue that I think warrants a significant analysis as to whether A, it's possible, but B, I do think it would help address some of the issues that we're seeing.
Now to Mr. Hayes and the Office of the Auditor General. At a previous meeting, I noted that the Auditor General's report mentioned that CBSA had added a firm to a task authorization under GC strategies rather than contracting the firm directly. And when I asked if you knew who that firm was at the time, you didn't, but then you actually provided me with the answer at the very end of the meeting, and I think it was KPMG was the firm that had been added to a task authorization form of GC strategies. And since this company was not approached to do the work, it was added to a task authorization form and became a subcontractor for GC strategies. Were you able to determine the value for money of their work? And I'm suspecting maybe not, because they were now a subcontractor. And can you comment on whether or not it would have been cheaper for CBSA to contract this firm directly rather than making them a subcontractor to GC strategies? And doesn't that have the appearance of providing GC strategies with an additional cut for the work that was done by this resource?
Sorry. What I would say about that, it was a confusing situation, quite frankly. Having a subcontractor that the agency identified put through the GC strategies contract means that the terms and conditions of that contract with GC strategies would apply, meaning that they would get their finder's fee for having a subcontractor, even though it was the agency that identified that resource. So ultimately, I think to the nub of your question, it costs more because they shouldn't have had to pay for GC Strategies' portion of that. They could have just paid KPMG for that if they put a contract directly in place with KPMG.
Thank you very much.
Thank you very much, Ms. Block. Turning now to Ms. Bradford, you have the floor for 5 minutes, please.
Thank you very much. So this particular topic has been, as you know, examined extensively. This is our 5th meeting and is referred to at OGO. So it's really been examined very extensively. So it's getting hard to come up with new questions. There was one that was actually posed to the Auditor General's office earlier, and I just want to get your take on it now, Mr. Jellick, from the opposite perspective, okay? So the Auditor General's report noted that Public Services and Procurement Canada challenged Canada Border Service Agency for proposing and using non-competitive processes for the ArriveCAN and recommended various alternatives. So from your perspective, from procurement, why did they do that?
Mr. Chair, thank you for the question. So if you're asking why they might have challenged the processes, it's likely due, again, I feel a little reluctant to comment on things that were not in our report that were found in the OAG report. I will say that likely there were inconsistencies in what CBSA and PSPC thought were best practices in terms of the road forward on that specific contract. Do I think that's a normal occurrence? Yes, absolutely. I think there's times where there's differences of opinion between the business owner and the contracting authority as to what methodology ultimately should be used. But I think the contracting authority should also have a very significant say in ultimately making the determination.
In your opening statement, so this is you did mention that there were overly restrictive requirements. And of course, we know that's because GC Strategies did them. And like those overly restricted requirements precluded pretty much anyone else from being competitive at all and being able even to bid. Why was this allowed? Why were they allowed to come up with what were clearly overly restrictive that would eliminate anyone else, that, like getting right to the very beginning?
So I will say it's a frustrating kind of circumstance in the sense that I think it should have been caught. I think it's a circumstance where everyone who was involved likely had more obligations on them than they acted on, right? And so the one thing I will point out, though, is what we found unusual, and this is something that we've been discussing since finalization of the report, is this idea that even when it was made competitive, and it was made competitive to 40 suppliers, 10 indicated an interest to participate. Not one of those suppliers challenged the restrictive nature of the requirement, which to me is baffling, particularly given that 10 of them expressed an interest. So either the community of suppliers accepted the fact that this was a geared process to a specific supplier, or something else had happened that I can't even hypothesize on. But I will say that these were drafted in such a way where, having the benefit of all the information now, it seems even more restrictive than it would have if you were involved in the process, because you might not have been aware of the 3 previous contracts that had been delivered on by that supplier. If you were within PSPC, you may not have been aware of the exact circumstances of those contracts. But like I said, I would expect that when it's as restrictive as these were on their face, right? So it doesn't take any technical expertise to be able to identify that these are heavily restrictive criteria. I would expect that PSPC would in future catch and push back on these types of criteria.
So you more or less answered my next question, because given your mandate, suppliers are supposed to complain to you if they feel the bidding process is unfair, right? Absolutely. So it's a mystery that, given that this clearly did look like it was, the bar was pretty high, and only one particular company met that no one brought this as a concern to you. Is that correct?
So, Mr. Chair, I'll just say one point of clarification. So we cannot review complaints from suppliers until the contract is awarded. In this circumstance, it would have been too late. However, there is another organization by the name of the Canadian International Trade Tribunal who would have authority, I can't say who would, but who may have authority to review any types of procurement-related issues in advance or prior to contract award. So overly restrictive criteria. But the first step in that process is really for a supplier to step forward and challenge by way of clarification or question during the live process. And again, like I said, I find it baffling that not a single one of those suppliers did so.
Thank you very much. That is the time, I'm afraid.
Just one, and maybe he can send it in, because I think it's really important. Do you have any suggestions for changes to the legislation so that this can be precluded, so that they can identify it during the process rather than after the process when the contract's rewarded and it's too late?
And briefly, please.
Mr. Chair, I just wanted to clarify. Are you referring to our legislation and regulation?
Right, right.
So I think it's very important that we have complementary jurisdiction with the Canadian International Trade Tribunal. We have a very good relationship with them to ensure that suppliers do have a recourse mechanism available to them. In this circumstance, I think the appropriate recourse mechanism would have been to the Canadian International Trade Tribunal.
Thank you. You're very welcome. Ms. Kuzi, you have the floor for 5 minutes, please. And this begins our fourth and final round. Over to you, please.
Thank you very much, Chair, and thank you very much to our witnesses for being here today. I want to thank you all so much for your work for Canadians for bringing to light so much of the mismanagement of the Liberal government of the ArriveCAN scandal. I was speaking in the House today on this issue, and it's evident from the evaluations of both of your offices that there is very little positive, if anything at all, to say about the ArriveCAN application. So again, I just thank you both very much for your work. Mr. Skellick, in November of 2021, you had a report on the CBSA, and you stated in the report, your office, the OPO, observed instances where CBSA failed to disqualify non-compliant bids and awarded at least one contract to a non-compliant bidder. File documentation was also found to be incomplete and significant concern, in several files. You recommended that they need to document every decision of business value, and the CBSA agreed to do this by June of 2022. And certainly there's a lot of water under the bridge since then. So based on this most recent report of yours, do you feel that these recommendations were followed or not?
Mr. Chair, thank you for the question. I'm sure the CBSA is not looking forward to our follow-up review because one of the things we will be looking at is specifically that recommendation about documentation. Now, that being said, the scope period was slightly different, obviously, for that review. It was 2018 to 2020. That being said, that predates the pandemic, right? And so this identifies the seriousness of the documentation deficiencies at the CBSA. And also in that report, thank you for bringing it up, you'll note that we identify the seriousness associated with the issue, and we specifically say the procurement file documentation was incomplete and of significant concern, right? And so this is back in 2021 that this was ultimately released, and I can give you the specific date. It was November 9th, 2021. So to say that they were unaware of their documentation practices, I think would be inappropriate. What I think the work of this committee and the work of other committees has done is it's elevated the importance of my office and the work done by the Office of the Procurement Ombuds. And I think not to say that the recommendations were not taken seriously, because they were, but I think there's an additional enhanced scrutiny associated with the work of our office by parliamentary committees, which I think will result in stronger and swifter action.
That's excellent news, and I'm actually very as well pleased to see your office elevated in terms of heeding advice and information, as well as your colleagues to the left of you there. So we saw a lack of documentation in 3 different agencies: the Canada Border Services Agency, Public Health Agency of Canada, and Public Services and Procurement of Canada, You mentioned a lack of compliance. How do you think then that compliance is ensured?
So, Mr. Chair, thank you for the question. The way we ensure compliance is by conducting follow-up reviews. So we do allow for the elapsing of 2 years, and we find that to be a sufficient amount of time to allow departments and agencies to react to the recommendations being made. And then we do a secondary review. The nature of the review depends on what we see, but it is something that we specifically contemplate doing, and then we issue report cards that will speak to whether the recommendation has been complied with or not.
And I have said several times in both live broadcasts as well as within the House that to me the most concerning thing about ArriveCAN is that I believe that it's a microcosm of how this government has operated, everything from the mismanagement, the lack of oversight. In your opinion, is the lack of documentation a systemic issue throughout all of the federal departments, or would it be specific to these departments based on your analysis?
Thank you for the question. So again, when I talk about baseline data, this is one area where we do have baseline data, and I would suggest that we've done over 17 reviews of departments and agencies in terms of the highest value and volume departments and agencies. And I would say the number one, if not 1A, maybe 1B issue is documentation. So this is not unique to these three departments. This is a struggle across the federal government. And I think that this is something that needs to be taken seriously. And like I said, I think the work of this committee and the OGO committee spotlighting the seriousness of the documentation deficiencies will work to actively and rapidly address the deficiency.
Thank you. Thank you very much. Turning now to Ms. Shanahan, you have the floor again for 5 minutes, please.
Thank you very much, Chair. And again, I find this very, very interesting to get the procurement side of this equation. Although it's not the usual purview of this committee, it is certainly clarifying a number of different things for me and reassuring me that indeed there are procedures in place. There are review procedures in place. Just a question to Mr. Zelic. Do you work with the Auditor General's office in any way? Do you collaborate in any way?
Mr. Chair, thank you for the question, and I'm glad my colleague Derek Mercereau actually is probably best positioned to explain exactly how we collaborated with the Auditor General's office on our review, so maybe I'll turn it over to Derek.
Yeah, sure. Just briefly. So our review was independent from the Auditor General's review, but early in the process, Alex had mentioned that we launched in January of 2023. We did have preliminary discussion around the same time because they were contemplating or had just announced that they were going to be conducting their audit. So we had a preliminary meeting, and then there was I believe 3 meetings throughout the year where we just had touch points with the two teams. And towards the end, we did share a copy of our report with the Auditor General, but we did complete independent projects.
Thank you for that, because I imagine between the expertise, even though I understand that the Ombuds office is more lightly staffed than the Auditor General's office, the expertise is certainly irreplaceable. Now, I would like to clarify one thing before I turn to the Deputy Auditor General. About the 76% of contractors who didn't do any work, because we're hearing that in the House, that it sounds like that they were paid and they didn't do any work. Can you clarify again, and I know you've done so several times already, but for the record, is it an incorrect statement then by the Leader of the Official Opposition that 76% of contractors who worked on ArriveCAN didn't do any work? This is a serious situation, and not speaking honestly about it shows how little, I'm sorry to say, the official opposition cares about this issue.
Mr. Chair, I just wanted to clarify, I believe the quote that you provided said that worked on, and I think the issue is that it's that 76% of people got paid, and not have done any work. And that's the thing that we did not say in our report, right? The bait and switch issue is that 76% of the time, some or all of the named resources were switched out and did not deliver any services. However, there were replacement resources provided who did the work and were paid for the work.
Well, thank you very much for making that clear, because indeed it's more important for us to understand what this bait and switch is all about, because this is how the gaming of the bidding system happened, which is a very worrisome thing to learn about, and certainly the unhelpful statements that have been made and incorrect statements made about your report do not do anything to help us to improve things going forward. I'd now like to turn to the Deputy Auditor General. Again, about PSPC and their role. Apparently they did challenge or ask the CBSA to run a competitive process and were ignored. Is this normal? Is this something that happens routinely?
I don't think I can comment on how routinely it happens. It is concerning that that officials from PSPC proposed some options to create some competition, but it wasn't received that way with from the CBSA perspective. I believe that there has been a request for information on that, the documents from PSPC, and I think the committee will be interested in seeing that.
And just to repeat a question that I asked earlier around the suspension of the task authorizations that PSPC has put forward, is this something that the Auditor General's office sees as a welcome development?
What we see as being really important in that initiative is that there is I think a focus on trying to get better specificity and detail in the task authorizations. So we support that. I guess I would just reiterate the fact that while there are controls and there are processes, laws, policies, etc., it is problematic to layer on too many processes and controls. It can grind things to a halt. The business government still needs to be able to move.
Thank you very much. I'm afraid that is the time. But encore une fois, Madame Sinclair Desgagnés.
Madame Sinclair Desgagnés, 2.5 minutes. I have a question that should be very easy for you to answer, Mr. Yeglich. Are there any constraints in procurement against employing 2 people at the same time in different departments? Is there anything that prohibits this type of situation?
So is there, Mr. Chair, thank you for the question. Is there a constraint about employing 2 people at the same time? I'm not sure I fully appreciate. Peut-être je vais entendre en français si c'est d'accord.
Je vais recommencer.
I'll start again. Is there any rule that prohibits the Department of Agriculture hiring the same 2 people to fulfill a contract, but the same 2 people can be working on a daily basis elsewhere in another department?
Preventing that from happening.
Est-ce qu'il ne devrait pas y en avoir?
Shouldn't there be a rule to ensure that it is, in fact, the proper people doing the proper work under the agreement?
The question is associated with the integrity of the supplier. So they make attestations, they have to provide a certain documentation. So if the concern is that they're doing work simultaneously with 2 departments and billing twice for the same work, I think they have to make attestations in regards to
Pas nécessairement le même travail.
Not necessarily the same work, but they're charging the same day twice.
Mr. Chair, in their timesheets that they would provide, they would have to indicate the time spent on the specific contract. So if they were not disclosing accurate timesheets, then that would be a breach of their contractual obligation. So there are rules preventing that from happening. Absolutely.
D'accord, donc il y a des règles. Qui fait?
So, okay, there are rules. Who does the necessary audits of that then?
So that's a difficult question in the sense that there is no level of coordination between departments for them to know ultimately if a supplier is working, simultaneously amongst multiple departments. I would suggest that is in fact happening. I will say, and perhaps if you'll allow, this is a plug for a global vendor performance management framework across the federal government so that information is shared about the performance of suppliers across the entirety of the federal government. It's something that I've actively been pushing for. I know that Public Services and Procurement has been implementing a vendor performance management framework within the department and are looking to pilot more ambitious pilots in the future. However,
Allez-y, terminez.
However, I think that will allow a better understanding of one supplier who acts with one department, and perhaps behaves well or poorly, for that same information to be shared with other departments and agencies, and then that would speak to address the concern that you've raised.
Brièvement.
Briefly. I don't even know what to say because it's so clear that something like that framework should have been put in place a long time ago. But isn't it up to PSPC to do the audit themselves in a sense to ensure that the person that they are contracting with is actually carrying out the work? How can it be that there aren't any people in PSPC who don't realize, whoops, we've just paid twice for the same day for the same person?
Question. I think the answer is also if PSPC is the contracting authority in both instances, then they would likely have that information. I guess I interpreted
that was a good answer. I want to stop you right there. Turning now to I pledge not to drive this much past our 2 hours, but that was a good answer. Ms. Gazan, you have the floor, and of course, if any member wants to pick up on that, they're welcome to do so as well. You have the floor for 2.5 minutes, please, Ms. Gazan.
Yes. So just for wanting to set aside and I just want to touch on the program for Indigenous businesses in federal contracting. So one of the contractors on behalf of the CBSA, Dalian, was procured and hired non-Indigenous suppliers to do the work despite the contract being issued under the TBIPS supply agreement and being open to qualified Indigenous suppliers under the procurement strategy for Indigenous businesses. However, and I find this very disturbing, the CEO of Dalian noted in another committee meeting that they did not need to hire Indigenous suppliers, and the rules are very bendable in this case, which is concerning because is this supporting equity or not, or is equity being used, or Indigenous people being used to get contracts? So it seems very unethical to me on a personal aside. I know that in your report that there were 6 bids received from qualified Indigenous suppliers, 5 of which were highly qualified and received maximum points on the technical component. So I want to know, what were your key findings in this area? I want you to explain why are Indigenous businesses and contractors ignored despite being compliant? And what do you think can be done to fix this issue? I mean, programs are put in place for a reason. Clearly, people are finding loopholes. So if you could respond to those 3 questions. Thank you.
Sure. So, Mr. Chair, specifically to the citation in the report, the issue that you've identified is an issue of transparency. So in that specific solicitation, it said up to 2 contracts would be awarded, when it was quite clear in the communications between the departments that the intention was to only award 1. The reason why we add that additional observation is because the incentive was to encourage participation from Indigenous businesses, and they received high participation from Indigenous businesses on the prospect of awarding 2 contracts, and ultimately only 1 was awarded. So we put that in there specifically for transparency purposes. It's very important to be clear with suppliers what the true intentions are in terms of the contract award. So I think if they had known only 1 was going to be awarded, that it rightfully should have indicated so. In terms of your reference to the procurement strategy for Indigenous business, I just want to read you the requirement associated with joint ventures. And it states that 51% of the ownership and control of the joint venture must belong to Indigenous business, and at least 33% of the total value of the work must be performed by Indigenous business contractor or by a combination of that contractor and other Indigenous.
So understanding it has to be 51%
Very briefly, Ms. Gahan,
owned. This is another example of where there is a failure in accountability, clearly. What can be done going forward to ensure that money that is to go towards Indigenous business actually lands in the hands of Indigenous people?
I'm going to ask for a written response, please. We're over our time, unless it's very brief.
And provide that. I think the answer lies in the audits performed by ISC. So these are self-certifications made by the suppliers. Indigenous Services Canada can audit the certification processes, and I would encourage them to do so. And it's also something that we're looking at our longer-term review plan.
Thank you very much. Turning now to Mr. Viersen joining us online. You have the floor for up to 5 minutes, please.
Thank you, Mr. Chair, and I want to thank the witnesses for being here today. I just want to go back to Mr. Jellick about JC Strategies helping to set the criteria for the contract they later received. Can you explain that just a little bit more?
So, Mr. Chair, thank you for the question. I don't want to deflect the question, but that was ultimately a finding that came from the OAG's report. That isn't something that we saw directly. I'd certainly be prepared to offer my views, but I'd prefer that the starting point be the Office of the Auditor General, if that's okay.
Well, we have them here.
Yes, thank you.
Mr. Hayes?
This was a concerning finding for us in this report. As the Procurement Ombudsman has said earlier in this meeting, it is not uncommon for suppliers to be engaged with people in departments and agencies. What has to be protected, though, is the integrity of procurement processes, in particular, making sure that there isn't an advantage that is achieved by a contractor working with people that are establishing future procurement processes. In this case, what we saw was that that this contractor was involved and had knowledge of particular requirements that ultimately made it into the request for proposals in the competitive contract. That, in our view, should not happen.
So they were basically getting a contract or a proposal that would only fit their company, is essentially what you're saying.
There is a risk that exactly that happened. Now, what we do say in our report is that the requirements for that contract were very restrictive, and I think the Procurement Ombudsman found the very same thing. In our view, whether or not it was like directly for them, it does have the impact of chilling competition and discouraging other bidders. And the Procurement Ombudsman spoke about the fact that it was perplexing that there were 10 bidders that expressed interest and did not ultimately submit a bid.
Okay. You also mentioned around it seemed like the government or the bureaucracy recommended KPMG to fulfill part of the contract that they had signed with GC Strategies. Can you shed a little bit more light on that? Given the fact that is this part of the same contract that they had been part of setting the criteria, then the government was then, or the bureaucracy was then providing them with somebody that could actually fulfill that contract?
In the case that you're discussing, I think I addressed it a little bit earlier, but if my answer was unclear, I'll just say that there was a contract in place with GC Strategies officials from the Canada Border Services Agency identified that KPMG could provide some work that would be helpful. That instead of having a contract directly with KPMG, the KPMG became a subcontractor for GC Strategies. Ultimately, we're concerned that with the way that happened, the agency was finding the resources for the contractor, and secondly, that ultimately the government paid too much because GC Strategies ends up getting a finder's fee for that work.
So GC Strategies gets a finder's fee for a company of which the bureaucracy provided that company, and they pay them a finder's fee for a company they never found. That's correct.
Essentially, that's the concern that we have.
Okay. Now, folks back home talk to me all the time, and they say, well, what's going to happen? Like, there seems to be a clear case of negligence in the least. What is there any ramifications for the people involved in making these decisions? What is if at some point we find the RCMP, I guess, criminal charges, but we've had people come here and say, well, I wasn't in the job before. What happens? What is a possible remedy for some of the people that were in these jobs and made some of these decisions?
I think there's a number of angles to that. There's a few processes that are underway, whether they are the internal investigation at CBSA. The RCMP is looking into allegations. We've had members of the senior public service speak about the fact that bonuses can be retracted if it's justified. And I believe that officials from the Public Service and Procurement Canada talked about possible recovery of amounts. Whether that can be achieved on the information that's available is an open question, but those are some of the recourses that may be available.
And thank you very much. That is your time, Mr. Viersen. I understand you'll be joining us on this committee. We welcome you.
Thank you.
And congratulations on the recent addition to your family. Turning out to Ms. Khalid, you have the floor for 5 minutes, please.
Thank you very much, Chair. So we'll start with Mr. Hayes, and can you just tell me how to pronounce your name, sir?
It's Yiglich.
Yiglich, got it. Thank you, Mr. Yiglich and Mr. Hayes. I appreciate that. So in the report, the Auditor General, she concluded that the CBSA, PHAC, and PSPC did not manage all aspects of the ArriveCAN application with due regard for the value for money. And now there have been some steps that have been taken since November to address these issues with that value for money piece. But I'm hoping that we can kind of dig into that a little bit more. So I know that delegated authority has been taken away from departments and agencies, and there's new rules and agreements and training that are being put into place. Are you able to talk about how that will address this specific concern of value for money? We'll start with Mr. Hayes and then go on to Mr. Yeglich.
Thank you. I mean, I would start by saying that some of the concerns that we had about not getting best value for money may not be addressed by some of these changes. In particular, the heavy reliance on external resources without having an analysis of how to reduce that reliance is an important finding from our report. I would also say that consistently requiring resources at the highest levels under a task authorization raises questions about value for money. And finally, the practice of extending contracts or adding time without changing the level of effort to us won't be addressed by some of the changes that are being proposed.
So we didn't do a value for money analysis, but we did have a section of our report that spoke to best value specific to procurement. So we made recommendations specifically as to how they could remedy that. And it goes back to one of the answers I provided, which starts with the selection methodology of 70-30, so 70% technical, 30% price. So obviously increasing the price component would be a starting point. There was also the discussion around the median bands and the need to make sure that that lower threshold is expanded, and only on exceptional circumstances where it's justifiable and explainable as to why you would want to limit it further, I think is another recommendation we made that I think would enhance best value. And then also on the replacement of specific individuals, back to then you should at least achieve the quality of service that you pay for. And so again, that 76% ties directly into that concept. And so diminishing the number of resources that are replaced would also speak to best value. So I think in terms of following up on our recommendations, I do see there being improvements associated with best value with procurement.
Thank you. I really appreciate that. I know that our member from the NDP wasn't able to get all of her answers in to the questions that she had asked. So if you want to take some time to maybe address some of those challenges that she had outlined as well. I did like her questions.
Sure. Ms. Kazan, are you still with us? She might have logged off.
She's there, but her camera's out there.
Oh. Ms. Kazan, one of your colleagues on the Liberal bench is offering
I know
2 minutes.
I heard. Okay, great. Just getting back, like I asked about Indigenous procurement, and there seems to be an issue of accountability around Indigenous procurement, and there's a whole issue of accountability, whether it was a procurement, whether it's knowing the amount spent that could have been saved internally. But going back to the hiring of Indigenous folks, how can that be mitigated so that programs that are designed for equity actually go to the people that it's supposed to go to, and in this case, Indigenous peoples?
So, Mr. Chair, thank you for the question. So, responded, albeit very briefly, in terms of who bears responsibility in ensuring that that is in fact happening. And I would suggest that there is a self-certification process involved for Indigenous suppliers. They have to retain information that would support that self-certification, but it's Indigenous Services Canada that has the right to audit the statements that are being certified by those Indigenous businesses to ensure that it is in fact Indigenous businesses who are benefiting as intended under the procurement strategy for Indigenous business.
So it seems to me there's a lot of levels to bureaucracy that are interfering with ensuring accountabilities in these programs, particularly because we're talking about hiring in one ministry and it having to be overseen in another ministry. It seems like an impossible bureaucracy in terms of maintaining accountability.
So, Mr. Chair, thank you for the question. I would say that Indigenous Services Canada, however, has exclusive mandate in this area. So regardless of what department or agency the Indigenous supplier is contracted under, these certifications can be audited by the same department. So there is continuity there. I think it's a question of how frequently these audits are performed. And so that's something perhaps that could be asked of the Department of Indigenous Services.
That concerns me because we're dealing with accountability and transparency issues in one area. And it seems like we also have accountability and transparency issues in other areas. But just going back to a former question that I asked. So according to the Attorney General, they indicated that, and I'll ask this of the Attorney General, they indicated that it's impossible to determine the total cost for ArriveCAN. Would you agree that that wouldn't have had happened had there been more regulatory mechanisms in place? And I ask that because I find it disturbing that it's impossible to determine the total costs.
There you are. Mr. Hayes, you'll have the last word on this, and turn it over to you.
Thank you. I think the best way to explain this is the words that the Auditor General herself used. There was a glaring disregard for basic financial management practices. When public funds are being spent, there should be clear and concise records showing exactly what those public funds are being used for and who approves them. It should be easy to follow through the dollar all the way through the financial system and out to the contractors, and that just wasn't able to be done in this case. So quite frankly, what should happen is the record-keeping practices should be greatly improved at the CBSA in order to address the glaring weaknesses that we found.
Thank you very much, and I want to thank our witnesses for coming in today. Appreciate it. I know we're here a little longer than expected because of the votes, but your patience is we thank you for that. And without further ado, I'll adjourn the meeting, and we'll see you all here Thursday.